Good morning, and thank you for joining Mayor Brown's Global Financial Markets teleconference series. Today's call is entitled From Landlines to Friend Requests. New CFPB rule tries to bring debt collection to the 21st century. My name is Stephanie Robinson, and I'm a partner in Mayor Brown's Washington, D.C. office and a member of the Consumer Financial Services Group. My practice focuses primarily on representing financial institutions and other companies in government enforcement matters and providing regulatory advice and counsel on consumer financial law. Before we get started, we have a couple of housekeeping items. As our regular listeners will know, this call is being recorded. We will be emailing an audio link to all participants should you wish to listen to the teleconference again or forward it to your colleagues. In addition, the recording session will also be available as a podcast on your preferred podcast platform. Since we will not have a Q&A session, please send your questions regarding today's topic by email to gfm@mayorbrown.com and we will respond promptly. This is the same email address on your invitation email. Joining me today are Anjali Garg and Dan Pearson. Anjali is a senior associate in our Washington, D.C. office and a member of the Financial Services Regulatory and Enforcement Group. She handles a broad range of federal and state compliance, examination, and government enforcement matters, including state and federal investigations and examinations regarding debt collection and servicing practices. Dan is also an associate in our DC office and a member of the Financial Services Regulatory and Enforcement practice. He advises clients on a range of regulatory compliance issues with a focus on state licensing. And with those brief introductions, we will now begin today's discussion. So on October 30th, the Consumer Financial Protection Bureau announced its final rule to implement the Fair Debt Collection Practices Act. And the FDCPA applies to debt collectors who are parties that regularly collect debts on behalf of others or who have purchased or otherwise acquired defaulted debt to collect. And the FDCPA prohibits a debt collector from using unlawful, abusive, deceptive, or unfair collection tactics in connection with the collection of debts. And it also contains an extensive list of prohibited practices. The CFPB's final rule that it issued in October amends the little-known Regulation F, which currently merely establishes some procedures and criteria whereby states can apply to the Bureau for exemption of a class of debt collection practices from the provisions of the FDCPA. This final rule was a long time in the making. Congress passed the FDCPA in 1977, and no significant regulations were promulgated to interpret it. It's been 4 years since the CFPB first released its initial outline of debt collection proposals, and it's going to be yet another year before the rule finally becomes effective on November 30th, 2021. So on today's call, we're going to discuss the scope of the rule, and we'll get into the key practice restrictions and requirements. And to start with, Dan, I'd like to turn it over to you to tell us about who this rule covers.
Thanks, Stephanie. The first thing to note is that the final rule does not change the scope of the FDCPA. Although the Dodd-Frank Act gives the CFPB broad regulatory authority, the final rule implements only the FDCPA and does not use the Bureau's broader regulatory authority to expand the FDCPA's reach. That means that the FDCPA continues to apply only to third-party debt collectors and not to first-party debt collectors, meaning companies that collect their own debts, such as creditors or active debt buyers. At the same time, the final rule does not reduce the reach of the FDCPA, as the rule's definition of a debt collector substantively mirrors the statutory definition. Before we get to the definitions, we want to note that the final rule doesn't address everything just yet. The Bureau intends to issue a separate rule this month that will clarify a debt collector's disclosure requirements and requirements relating to the collection of time-barred debt. I'll start by summarizing the key definitions used in the final rule, because the definitions will affect the reach of the rule's substantive practice requirements. Probably the most important definition in the final rule is the definition of a debt collector, as that term largely controls the persons to whom the final rule's requirements apply. The CFPB did not throw us any surprises here, as the final rule's debt collector definition is materially identical to the FDCPA's definition and the definition that was initially proposed when rulemaking began. As such, the final rule defines a debt collector essentially as any person whose business has debt collection as its principal purpose or who regularly collects debts owed to another. The official comments to the final rule incorporate the Supreme Court's 2017 Henson v. Santander decision, which held that a company can collect defaulted debts that it has purchased from another entity without necessarily being a debt collector. The Bureau also declined to exclude mortgage servicers or attorneys from the definition of a debt collector, despite the urging of some commenters to do so. The FDCPA and the final rule generally regulate a debt collector's contacts with consumers. The final rule defines a consumer to mean any natural person obligated or allegedly obligated to pay any debt. But note that for purposes of a debt collector's communications, a consumer may also include a spouse, parent of a minor, legal guardian, estate executor, or confirmed successor in interest. Many of the final rule's requirements apply to a debt collector's communications. The final rule defines communicate or communication broadly to mean the conveying of information regarding a debt directly or indirectly to any person through any medium. The Bureau clarifies that under this definition, messages that do not contain information about a specific debt, such as advertisements, will likely not qualify as communications and will therefore not be subject to the communications-related requirements under the FDCPA or the final rule. A communication does not include what the final rule calls a limited content message, which I'll explain in a moment. The final rule regulates not only communications, but also attempts to communicate that do not result in an actual communication, such as where a consumer does not answer a debt collector's phone call. Attempt to communicate is a separately defined term that means any act to initiate a communication or other contact about a debt with any person through any medium, including by soliciting a response from such person. As with the definition of communication, general marketing and other messages that do not contain information about a specific debt are not attempts to communicate. However, unlike a communication, an attempt to communicate does include a limited content message. So what is a limited content message? A limited content message is a voicemail message for a consumer that must include certain mandatory information, may include certain optional information, and must not include anything else. A limited content message must include 1. A business name for the debt collector that does not indicate that the debt collector is in the debt collection business. 2. A request that the consumer reply to the message. 3. The name or names of one or more persons whom the consumer can contact to reply to the debt collector. And 4. A phone number or numbers that the consumer can use to reply to the debt collector. A limited content message may also contain the following optional content: a salutation, the date and time of the message, suggested dates and times for the consumer to reply to the message, and a statement that if the consumer replies, the consumer may speak to any of the company's representatives or associates. If the message contains anything beyond the mandatory and optional language, it is not a limited content message and may constitute a communication, which would subject the message to all of the requirements that the FDCPA and the final rule impose on communications. To reiterate, only a voicemail message can be a limited content message, not text messages or oral messages. Now that we've covered the most important defined terms used in the final rule, I'll turn the call over to Anjali to discuss some of the practice requirements that the final rule imposes on debt collectors.
Thanks, Dan. So although the final rule largely mirrors the statutory language of the FDCPA, it also clarifies some of the statute's more ambiguous provisions, such as those related to call frequency, and also establishes a framework for engaging in electronic communications with consumers, among other things. When the FDCPA was enacted in the 1970s, the drafters probably didn't imagine a world with social media, text messages, or email. In promulgating the final rule, the CFPB has also left open the possibility of future rulemaking to address communication tools that haven't even been invented. The final rule creates two separate processes for text messages versus email communications. However, rather than creating direct affirmative requirements for these types of media, the final rule creates a bona fide error defense for texts and emails that would result in an illegal communication with a third party. The various methodologies are complex, and I recommend reading them very carefully, even though I'll walk through them right now. With respect to text messages, the debt collector can send texts based on two situations. One, based on prior consent, or two, where the consumer has used the number to communicate with the debt collector via text message in the past. Both methods are designed to ensure that debt collectors do not communicate with consumers at numbers that are no longer assigned to them. Under the prior consent method, the debt collector can text the consumer if the consumer provided direct consent to communicate via text at that number and has not withdrawn that consent, and within the 60 days, either the debt collector obtained renewed consent from the consumer to text at that number, or confirmed that the number hasn't been reassigned based on a search of a, quote, complete and accurate database. The alternative method for communicating with consumers via text message is the consumer use method, which requires that the consumer previously used that number to text with the debt collector, not just via phone communications, and the consumer has not opted out of text to that number, and within the past 60 days, either the consumer sent a text from that number to the debt collector or the debt collector confirmed that number hasn't been reassigned, again, based on a search of a complete and accurate database. With respect to email communications, the debt collector can email with a consumer based on three different situations. First, through the prior direct communications method, which allows email communications where the consumer either used the email address to communicate with the debt collector about the debt and has not since opted out, or the debt collector received prior consent to use that email address and the consumer has not withdrawn that consent. Under the prior creditor use method, which is the second method, the debt collector can communicate with the consumer at an email address based on the fact that the creditor communicated with the consumer, but only if 5 criteria are met. First, the creditor received the email address from the consumer. Second, the creditor used the email address to communicate with the consumer about the account, and the consumer did not ask the creditor to stop using it. Third, before the debt collector used the email address to communicate with the consumer about the debt, the creditor sent the consumer a written or electronic notice containing certain required disclosures. Fourth, the opt-out period has expired and the consumer has not opted out. And 5, the email address has a domain name that's available for use by the general public, such as Gmail, unless the debt collector knows that the address is provided by the consumer's employer. Only after these 5 criteria are met can the debt collector use the prior creditor use method. The third option to communicate with a consumer via email is through the prior debt collector communications method, which allows emails where any prior debt collector obtained the email address using the prior direct communications method or the prior creditor use method, and the immediately prior debt collector used that email address to communicate with the consumer, and the consumer did not opt out of the communications. In addition to these different methods for obtaining consent or allowing the debt collector to communicate via email, there's also a prohibition in the final rule on using work emails. Debt collectors are prohibited from attempting to communicate with consumers using an email address that the debt collector knows or should know is provided by the consumer's employer, unless the email address meets the criteria for the prior direct communications method or the prior debt collector communications method previously described. In addition to the email and text message communication restrictions in the final rule also prohibits attempting communications with persons, not just consumers. This restriction includes third parties through social media, particularly if the communication is viewable by the general public or the person's social media contacts. Debt collectors can send private messages to these persons via social media unless the consumer requests that the debt collector not use that medium. They can send private friend requests, but must disclose their identity as a debt collector. Finally, debt collectors can send private social media messages to third parties, but only for the purpose of acquiring location information. Regardless of the form of electronic communication, be it text, email, or social media, debt collectors must include a clear and conspicuous opt-out notice and a reasonably simple method for actually opting out. Again, the final rules provisions on these various electronic communications are detailed and complex, and I would expect the Bureau to issue additional practice guidelines in the coming year. However, in the interim, debt collectors should closely evaluate these different restrictions and implement processes to make sure that they can comply. In addition to restrictions on electronic communications, the final rule makes certain clarifications to communications with third parties. The final rule restricts communications with anyone other than the consumer's attorney, consumer reporting agency, creditor, creditor's attorney, or debt collector's attorney, except for, among other things, for the purpose of acquiring location information. This largely mirrors the statute. However, the final rule does not adopt the proposed rules commentary, which would have provided a safe harbor for limited content messages left with third parties who answer the consumer's home or mobile phone numbers. The final rule adopts the proposed rules requirements for communications with third parties for the purpose of acquiring location information, which again generally reflects the statutory language. In addition, the final rule codifies some of the FDCPA's restrictions on communicating with consumers at unusual times or places, with the default restriction on communicating with consumers before 8 a.m. or after 9 p.m. local time to the consumer. The time and place restrictions apply equally to phone and electronic communications, including text messages or emails. The final rule adopts the conservative approach that many debt collectors already use to determine a consumer's location for the purpose of the FDCPA's communications time restrictions, where, for example, the consumer's cell phone area code suggests that the consumer resides in California, but their zip code suggests they reside in New York. In this circumstance, the debt collector may only use a time that would be convenient in all of the locations at which the debt collector's information indicates the consumer might be located. In other words, you would take the more conservative number. Debt collectors do not have to attempt to determine the consumer's actual location. The final rule presents some subjective challenges for debt collectors in determining whether a time or place is, quote, inconvenient to a consumer under the FDCPA. For example, the official commentary contains an example where a consumer responds no when a debt collector asks if there's a convenient time to call on a weekend. In that situation, the debt collector would be prohibited from attempting to communicate with the consumer on the weekend. This would be true regardless of medium. If a consumer initiates communications from previously designated inconvenient time or place, the debt collector may respond only once at that time or place through the same medium, such as by sending an automated reply to an email message. I'll now turn it to Stephanie to discuss some of the other practice restrictions contained in the final rule.
Okay, thanks, Anjali. I just want to talk for a few minutes about the call frequency restrictions in the rule. So the FDCPA prohibits a debt collector from making repeated or continuous telephone calls. And the final rule clarifies this by setting some call attempt restrictions. In general, in connection with the collection of a debt collector must not place telephone calls or engage any person in telephone conversation repeatedly or continuously with the intent to annoy, abuse, or harass any person at the called number. Under the rule, a debt collector is presumed to violate the FDCPA if it places a telephone call to a particular person more than 7 times within a 7-day period or within 7 days after having engaged in a telephone conversation with the person in connection with the collection of a particular debt. It also clarifies that a debt collector is presumed to comply with the FDCPA's prohibition if the debt collector places a telephone call not in excess of either of those call frequencies. Now, if you noticed, I said in connection with a particular debt because the rule establishes presumptions of compliance and violation based on the debt collector's call frequency in connection with a particular debt. So if the debt collector places a call and initiates a conversation or leaves a voicemail about one particular debt, the debt collector counts that call as a call in connection with the collection of that debt. If the call is about more than one particular debt, the debt collector counts that call as a call in connection with the collection of each such debt. In the case of student loan debts, though, the term includes all student loan debts that are serviced under a single account number at the time the debts were obtained by the debt collector. So I'll give you some examples. If the call is unanswered or does not result in a conversation about any particular debt, the debt collector nevertheless has to count it as a call or conversation in connection with the collection of at least one particular debt, unless an exception applies. In this case, it doesn't matter which debt the debt collector intended to discuss. If the debt collector is attempting to collect a medical debt and 2 credit card debts from the same consumer and places a total of 21 unanswered calls within 7 days, he is still presumed to comply with the rule and the FDCPA if he counted 7 as unanswered calls in connection with the medical debt and 7 to each of the 2 credit card debts. This presumption of compliance stands even if the debt collector intended to discuss more than a single debt if any of the calls had resulted in a telephone conversation. And the official commentary to the final rule provides a lot of examples like this to illustrate how the rule's call frequency restrictions will operate. I mentioned that there are some exceptions under which certain calls are excluded from the telephone call frequencies. So calls placed within 7 days of receiving the person's consent don't count. Calls that aren't connected to the dialed number don't count. If the call results in a busy signal or not in service message, for example, that doesn't count. But if the call rings, or if it goes straight to voicemail without ringing, or if it connects and subsequently drops, all of those count towards the call frequency restrictions. And lastly, calls placed to the consumer's attorney, the consumer reporting agency, to the creditor or its attorney, or to the debt collector's attorney do not count. The final rule provides a non-exhaustive list of factors that may be used to rebut the presumption of compliance or of a violation. The frequency and pattern of telephone calls the debt collector places to a person, including the intervals between them, are factors that may rebut the presumption of compliance. So if the calls were placed in rapid succession, for example, that could rebut the presumption. The example provided in the commentary to the rule is 2 calls within 5 minutes. And similarly, if calls are placed in a highly concentrated manner, such as 6 or 7 times in one day, that too could rebut the presumption of compliance. Other factors cited in the rule include the content of prior communications, such as if the person had previously informed the debt collector that he was refusing to pay the particular debt, as well as the debt collector's conduct in prior communications, such as if he had used threats or profanity in prior calls. Those could all be factors to rebut the presumption of compliance. In contrast, certain factors may rebut the presumption of a violation. So if, for example, the debt collector placed a call to comply with applicable law, such as to inform the consumer of available loss mitigation options in compliance with the CFPB's mortgage servicing rules, that compliance with applicable law is a factor that may rebut the presumption of a violation. Other factors cited in the commentary to the rule include responding to a consumer's request for additional information, calling in connection with settling active debt collection litigation regarding the debt, and calling to alert the consumer to an opportunity to avoid a demonstrably negative effect relating to the collection of the particular debt, where that negative effect is not in the debt collector's control and where time is of the essence. And one example that's given to illustrate that one is to enable the consumer to avoid a late fee that would be charged by the creditor for a payment that failed to process, where the charging of that late fee is out of the debt collector's control and where time is of the essence. I want to shift gears now to turn to just one more practice restriction under the rule, and that relates to the transfer of paid or discharged debts. So the final rule prohibits debt collectors from transferring debts that it knows or should know have been paid or settled or discharged in bankruptcy. That means no selling, no transferring for consideration, and no placing for collection these debts that are no longer owed. there's 3 exceptions to this prohibition where the debt collector may transfer the debt for consideration. One is where the debt is transferred to the debt's owner. The second is where the debt is transferred to a previous owner if the transfer is authorized under the original contract between the debt collector and previous owner. And the third is where the debt is transferred as a result of a merger, acquisition, purchase, and assumption transaction, or a transfer of substantially all the debt collector's assets. Unlike the proposed rule, the final rule also accepts secured claims in bankruptcy. The debt collector may transfer a debt that has been discharged in bankruptcy if the debt is secured by an enforceable lien and the debt collector notifies the transferee that the consumer's personal liability for the debt was discharged in bankruptcy. And the restriction on transfers also does not prohibit the securitization of a debt or the pledging of a portfolio of debt as collateral in connection with the borrowing. And with that, Dan, I'd like to turn it back to you to hit some of the highlights from the remainder of the rule.
Thanks, Stephanie. To close out the call, I'll run through some of the miscellaneous other topics addressed by the final rule that the industry should be aware of before the rule takes effect. First, cease communication requests. The final rule adheres closely to the FDCPA in its regulation of cease communication requests. Debt collectors must honor a consumer's request to cease communications if the request is written, which includes electronic written communications under the e-Sign Act. Despite the urging of consumer advocates, however, the final rule does not require debt collectors to honor oral cease communication requests. However, a consumer can tell a debt collector to stop communicating with them through a particular medium, such as phone calls, orally or in writing, and the debt collector would thereafter be prohibited from placing telephone calls to the consumer. Next is disputed debts. The final rule adopts the FDCPA's prohibition on the overshadowing of a consumer's rights to dispute a debt or request information on the original creditor. This means that a debt collector may not engage in collection activities or communications that are inconsistent with the validation of debt disclosure, which advises the consumer of the right to dispute a debt and to request the name and address of the original creditor, among other things. The overshadowing prohibition applies for the 30-day validation period following a consumer's receipt of the written notice of debt. The final rule's official commentary also clarifies that consumer disputes submitted in writing include disputes submitted electronically through the debt collector's email address or website portal. Electronic disclosures. The final rule requires debt collectors to send disclosures in a manner that is reasonably expected to provide actual notice and in a form that the consumer can keep and access later. Required notices that are sent electronically, such as validation of debt notices, must be done in accordance with the e-Sign Act. Litigation. The final rule does not adopt the proposed rule's safe harbor from the FDCPA's prohibition against misleading representations for lawyers and law firms submitting litigation materials. The proposed safe harbor was intended to clarify when a lawyer makes a misleading representation by filing court documents that the lawyer was not meaningfully involved in preparing. The CFPB determined that the proposed safe harbor would not provide greater clarity as to the meaningful attorney involvement standard, but the Bureau said that it will continue to monitor the case law to assess whether a future rulemaking would be desirable. Record retention. Under the final rule, debt collectors generally must retain records evidencing their compliance with the FDCPA and the final rule for 3 years. The record retention period begins when the debt collector starts collection on the debt and runs until 3 years after the debt collector's last collection activity on the debt. Although the transfer of a debt to another debt collector would be the last collection activity starting the 3-year countdown, a bankruptcy discharge would not necessarily start the clock running if the debt collector continued to make collection efforts. For telephone call recordings, however, the record retention period is 3 years from the date of the call, even if collections are still ongoing when those 3 years expire. The official comments provide examples of records that debt collectors must retain, including telephone call logs and copies of documents evidencing compliance with validation of debt notices and delivery requirements. Records do not need to be kept in paper form if they are easily accessible. Next is relation to state laws. The final rule provides that debt collectors subject to the FDCPA are not exempt from state laws regulating debt collection, unless the state laws are inconsistent with the FDCPA or final rule. If there is an inconsistency, state laws are preempted only with respect to that inconsistency. The final rule clarifies that the state law is not inconsistent with the FDCPA or final rule if it provides greater protections to consumers. Thus, the FDCPA and the final rule function effectively as a floor for the regulation of debt collection. States may impose additional requirements or provide additional consumer protections, and these are not preempted. Finally, the rule implements a procedure provided under the FDCPA by which a state can apply for a determination from the CFPB that a class of debt collection practices within that state are exempt from the FDCPA. These procedures are already set out in the existing Regulation F, but the final rule makes minor changes for clarity and to mirror the statutory language, and moves these procedures to a new appendix. Under these procedures, a state can receive an exemption determination from the Bureau if the state's regulation of debt collection is substantially similar to the FDCPA and the final rule, and the state's requirements are adequately enforced. The final rule sets out the exact procedures for obtaining this exemption, but this provision is rarely invoked, and only Maine has obtained the exemptions since the FDCPA's enactment. With that, I'll turn the call over to Stephanie for some closing words and housekeeping matters.
Okay, thank you, Dan. Thank you, Anjali, and thank you to our audience for tuning in today. A few brief reminders. You'll receive an email with a link to the recording of today's call, and the recording will also be available as a podcast in your preferred podcast program. Lastly, as mentioned before, if you have any questions related to today's content, please email them to gfm@mayorbrown.com. Thank you again for your participation. You may all now disconnect.